The first case on the docket today is DONOFRIO and POSEY versus Broker.
Good morning.
Good morning.
I'm Thomas A. Smith, representing the appellants in this case, and I would like to reserve some time.
How much time would you like?
At least 5 minutes, Your Honor.
I'll give you a warning at 5 minutes.
Thank you. This case is somewhat of an embarrassing fact situation because, unfortunately, I would have been involved in the case from the inception. And I say embarrassing only because it's weird that we're here today based upon our position that the court had no jurisdiction. Just to briefly review the facts of the case, which I'm sure the court is already aware of, this case involved an initial action brought against a successor trustee to a trust created by Mr. James DONOFRIO. Mr. DONOFRIO had initially had this trust set up while he was alive and competent, named in his trust a successor trustee in the event that he became incapacitated as may be determined by a physician. Did not require any adjudication of incapacity. As he progressed, he lost his wife, he was elderly, and Mrs. Broker, who was named as the successor trustee, went to a family physician who determined that he was incapacitated, and she essentially took over the entire assets of the estate. In the meantime, prior to this, he had already amended his trust and named Michael DONOFRIO, who was a nephew, and John POSEY as the successor trustees. After she took over and he did ultimately become adjudicated as incapacitated, they sought to acquire the assets from Ms. Broker. She essentially told them she wasn't going to recognize them as the trustees, so they filed suit in 2000 against Mrs. Broker, essentially claiming conversion, refusing to turn over the assets to rightful trustees, and that litigation proceeded. Ultimately, at some point, there was a mediation ordered. In the initial case, the two children were not named as party to the suit, but the two children were named as the beneficiaries of one of the trusts. The trust set up at the time of death. The trustees were ordered to divide the trust to 1/3 to go to Michael DONOFRIO, and then he was to be terminated as trustee. He would no longer act as trustee of the trust. Then there would be the other 2/3 would be for the benefit of the two minor daughters, and that John POSEY would then act as the sole trustee of that trust, which incidentally has not been accomplished yet. Under the terms of the trust, that was to happen when the estate was closed, and at this point...
You would agree that the trial court acted correctly in appointing the guardian, having recognized that at issue was a matter that affected unrepresented minors?
Absolutely. No question with that. The court acted properly in doing that. The problem we have is that we believe that the court ultimately, the authority got exceeded. Because if you look, and the two documents, the only two basic documents I will refer to would be the document which appointed the guardian ad litem, which by its specific terms said that the guardian would act for the purpose of representing their interest in the court-ordered mediation of this matter and through the completion of the litigation. Now, admittedly, we take the position that that does give a time frame once the litigation is completed. Jumping ahead, the court then entered the order, which we believe is dispositive, was entered in May 2004, which incidentally was prepared by Mr. Eggert, who was the counsel for the minor children, the guardian. And in that case, it says it is ordered and judged that all claims, cross-claims, third-party complaints, and other claims in the above style matter are dismissed with prejudice and except as otherwise provided in the mediation agreement approved by the court. All parties to the action shall bear their own attorney fees and costs. I believe under the law that that ended the case. It was over. I don't think that, and I think also under the law, the guardian ad litem was terminated because that terminated the action in the litigation and therefore his duties as guardian ad litem was terminated.
In making that argument, you cite the 84 Lumber Company versus Cooper, is that correct?
I believe so, Your Honor. Yes, sir.
Did you happen to shepherdize that case?
I think we did.
Because you don't cite the case from the 4th District Court of Appeal, MCR funding, which expressed direct conflict with that case on the same point for which you cited.
Well, Your Honor, I apologize for that. We missed that. I thought we had shepherdize that.
Okay.
To go on further, however, what happened was that action continued in the case. It got transferred from Hillsborough County to Hernando County, and then some action was taken. I can't explain to you why that issue wasn't raised. I could give the best argument I can tell you. I think the best reason was that essentially the activity was non-adversarial. Things were going on, but the Mr. POSEY and the trustees had no objection to.
Would you argue that if the guardian, to protect the interest of the minors in the case, had an issue, that he could go back in the probate court, and that was the proper procedure, not resurrecting this case? Is that your argument?
Yes, sir. I believe that's correct. I think that he could, well, either, I think, well, let me back up to answer that. We believe that what happened in this case, based on the record, was Mr. Eggert, in a sense, morphed into more than just acting as a guardian. I think he became more of an advocate for the daughters, which we don't have a problem with necessarily.
Well, in order to protect the interests of the children, shouldn't he be involved in the case to make sure that, there's a proper accounting, that the assets are being preserved, that the assets are not being wasted?
Right. We don't have a problem with that, and I do say, and I think we mentioned in the brief, that the proper remedy would have been gone back to file a supplemental petition, serve Mr. POSEY, and proceeded on that basis.
Is it your argument that once a case is voluntarily dismissed, it can never be resurrected? There can be no ancillary litigation going on?
No, not at all. No, I think, but the proper remedy, it happens a lot in such as divorce actions, where you bring an ancillary, and under the rules, you bring a petition, but you serve summons and you serve the party. One of the big problems that...
Well, would you consider this ancillary litigation in this probate case, guardianship case?
I would.
So, but you don't think that could resurrect the case? In essence, you have to start all over again?
I think that it's my belief that with this order in place, where she dismissed all the claims, I don't think that there was anything left that could be resurrected. There was no reservation of jurisdiction, and I think that the guardian would have to file an initial supplemental petition in order to do that.
But you didn't raise that below, correct?
Pardon me?
You did not argue that below, correct?
No, we did not. But again, I believe the answer to that, or our position on that, is that it wouldn't have to be. It could be raised in a particular form.
That's where it would have been helpful if you jeopardized that case.
That's why I apologize.
The case that you cite says generally subject matter jurisdiction can be raised at any time. The 4th DCA case distinguishes subject matter jurisdiction that can be raised at any time, which they say is jurisdiction over the type of case, or the ability to hear a certain type or class of case, from case jurisdiction, which is the ability to hear a specific case within a general broad class of cases. And the 4th DCA says with respect to case jurisdiction, that has to be, an objection has to be contemporaneous, and you can waive that and thereby submit yourself to the jurisdiction of the court with respect to case jurisdiction, which is what you're talking about. So it would be helpful, since there's a potential, an apparent conflict in the DCAs, if we're going to have to address that issue, if it had been briefed thoroughly on both sides. And it makes the oral argument, in my view, very unhelpful, because I can't really ask you about your case that you should have cited and should have raised but didn't.
Judge, I think, though, our position is that it's not just case, because while they would have inherent jurisdiction to do so, I think my personal belief is that like, for example, removing him as trustee goes beyond the parameters of that case. While they had the opportunity and had the duty, and the court obviously should have appointed the guardian to protect the interest in the mediation, the settlement, it's much like a negligence case to settle it. But how far can they go beyond that would be our position. That it would be not within that parameters. That's why I think that to do what they want to do, for example, to remove the trustee, and to do those types of
I guess the
activities.
problem is the James case and others talk about the inherent power and authority, actually the obligation of the court to protect minor children who appear before them in cases such as this.
That's
And
correct.
if you had raised that timely below, the guardian could have filed a supplemental petition. You're saying it could have been done in this case to reopen the case. I mean, now that there's been a finding of potential misconduct and the court has taken the steps that it was obligated to take, you're up here saying, well, you know, there's no jurisdiction when you allowed the proceeding to go forward below the evidence to be taken and everything to happen below.
Well,
Which could have been done if you had raised the objection timely pursuant to a supplemental petition.
I can't quarrel with that argument. And like I say, the problem is that, let me back up a second again. I think the problem is that the original action only involved arresting the assets from the other trustee. And it really didn't get involved in the management or the affairs and so forth. So I have a problem intellectually. I have a problem saying, well, this type of activity that you're doing now would be under that case, and you could open it up or reopen that case in effect, as opposed to having to file a new case and bring those issues before it. Part of the problem is that I find, and my client finds, is that Mr. Posey, who is really the brunt of all this because they've issued orders against him and removed him, et cetera, was really never had the opportunity to be served the formalities that normally you would have if you were going to take that type of action. The problem I think that we all got led into, I confess that, was that, you know, some of the things that were before the court was a car for the child. Nobody had any problem with that. There were some other things that everybody was trying to work out. There was a question about the bond. We tried to work all those things out, and it was never became adversarial. I think the real point when we took a look at this case again was the last petition that was filed in Hernando County, and at which point we even filed a supplemental voluntary dismissal to try to get it out of that context. And if they wanted to proceed to bring a regular new action to formally advise Mr. Posey of what was happening and giving him an opportunity to really to defend against that and have a full formal hearing. And I believe that was what occurred. So we believe that once the case was dismissed, and that's pretty unequivocal when the judge signed that in 2003, that essentially what was happening was voluntary acquiescence, and it was my belief that, and I apologize for not having that case, but it was my belief in reading the law was that they didn't have jurisdiction, and just by merely proceeding, we wouldn't be, in effect, conferring jurisdiction on them, because it would be, in effect, by agreement or acquiescence. And based upon that, we believe that it should be reversed, and that order set aside, and I'll reverse, save my time.
You got about 7 minutes.
Thank you.
Good morning. May it please the court. My name is Jim Eggert. I'm the guardian ad litem in this case, and I'm appearing on behalf of myself. This matter involves the appeal of an order dated June 9, 2006, an order that removed John Posey as trustee of a residuary trust. And I believe the applicable standard of review for this court is set out in the Munderland versus Wingster case, which is the standard that has been set out by this court in 2002 for determining the determination of subject matter jurisdiction in a case. That determination is subject to an abuse of discretion standard. The Kanakaris case in 1980, the Florida Supreme Court set forth the applicable standard for determining whether a court has abused its discretion. And in that case, the court stated that in reviewing a true discretionary act, the appellate court must fully recognize the superior vantage point of the trial judge and should apply the reasonableness test to determine whether the trial judge abused his discretion. If reasonable men could differ as to the propriety of the action taken by the trial court, then the action is not unreasonable.
Are you suggesting that a trial judge has the authority or discretion to proceed in a case in which he doesn't have subject matter jurisdiction?
I think that the issue is whether the trial court has the power to invoke its jurisdiction and to continue its jurisdiction in this case.
It appears to me that these are questions of law. There's no question of fact as to whether the order of dismissal was entered. The question is, what's the legal import of that document? Am I incorrect there? I mean, I don't see any discretion that the trial court has. Either he has subject matter jurisdiction or he doesn't.
I understand the nature of the question, Your Honor. Yes, the position that I'm taking is that the court invoked its jurisdiction when it appointed an ad litem and also invoked its jurisdiction in the order approving the settlement, which required a bond, and it began to take steps in order to protect the minors. That invocation of the jurisdiction was itself a discretionary act.
Are you arguing that the trial court has discretion to just decide that it wants to review a matter and do it on its own accord without any pleading that invokes the jurisdiction of the court?
No, Your Honor. I do take the position, however, that the court has the inherent power to protect minors, which I believe it invoked in this case.
Well, why not
So
require,
if I see a child in the audience, I can just, as a judge, decide I want to deal with how that parent's dealing with that child? I mean, that seemed to be the tenor of your briefs. That I'm walking along the street, I'm a judge, I can sort of do whatever I want to if I see a child that I think's not being treated properly. I mean, that's certainly far afield from my notion of what
I would agree that would be very far afield, Your Honor.
Okay.
But again, I think that would be an abuse of discretion. However, for you to do that, with all due respect, it would be an abuse of discretion. So it is subject to a standard, which is what I'm suggesting. It is subject to a standard. I don't think it was an abuse of discretion for the court, for example, in this case, to appoint a guardian ad litem to continue to exercise
Nobody's
jurisdiction.
contesting that, the appointment of the guardian ad litem.
Yes, and the outgrowth of that was, I think, at least on.
Let me ask you this.
Yes,
If
Your Honor.
we agree with the other side and decide to side with the second DCA and determine that once a case is dismissed, there is no subject matter jurisdiction to proceed, then what's the practical effect in this case on these minors and on you as their representative or guardian?
Well, if you agree with their side, as I'm understanding their position, is that they're saying that the court had no jurisdiction whatsoever to act.
That the order that you prepared that was entered that said this case is over divested the court of subject matter jurisdiction. That's the position.
Well, I did not prepare that order.
Okay.
So
I thought that's what I heard.
that is what you heard. That is not. I think Mr. Hearn prepared that order, who represented the other side. But that's obviously not a matter of the record. But I'm sorry, your question, Your Honor. I want to make sure I address your question. Could you please repeat it?
I said that the argument is that once that order was entered, it divested the court of subject matter jurisdiction. And obviously, if the court doesn't have subject matter jurisdiction, it can't do anything in it.
Correct. Correct. I
If you would
think the
address-
practical effect of that would be to make a nullity of any subsequent orders. That would be my understanding. If that was the way the
Could
court
you
was
then
going.
file your own independent action to affect the same result ultimately?
That would raise the question of my authority under the appointment itself, which is through the conclusion of the litigation, is the way the language was framed.
Do you believe that you could file a supplemental petition under this case number to try to affect the same result that you affected?
Under that language, I did not believe that that would be appropriate, because the conclusion of this litigation meant this litigation. And my position has been that this litigation had not been terminated because the court, in approving the settlement, had required the posting of a bond and then took further steps to continue to protect the minors, and had not discharged me or taken any other steps to end my role. Despite my request to the court, do you want me to continue in this or not? He clearly wanted me to continue on in my role until at any point the trial court could have said, I'm not going to entertain these motions. I think the court was interpreting its own order of my appointment by the way it conducted itself in the case to continue to entertain the motions.
this case was in the probate guardianship division, is that correct?
I believe that it was not actually, Your Honor. Oh, yes, it was. It was in Hillsborough County. It was the probate guardianship division. The venue was transferred.
Is there still a guardianship in existence?
There was never a guardianship, an independent guardianship with respect to these minors.
Is there an open probate case?
There is At this time, I don't, is the probate case, and I'm just not, I want to make sure.
Well, from the
probate
record,
case
is there a
closed on-
probate case ongoing to either?
There was a probate case relating to the decedent that was near the cusp of concluding, and may still be near the cusp of concluding.
And are the
As of this
children
day, I'm not sure
still,
whether
are
it's
the
closed.
children still juveniles?
Yes, they are, Your Honor.
And your argument is that they can get no relief if this case is dismissed? That is through the, either the trust or through the probate case? Is that your argument?
That would be, well, that would be my position. I think that the vindication of the court, what the court had done in this case was it had entered certain orders requiring Mr. Posey to act. And I think the argument that came up here earlier was that there needs to be an independent action. We're discussing that issue, whether it's an independent action.
You would agree if there's an open probate case that the beneficiaries of the assets can go back to the probate court if there's an error or if there's malfeasance, misfeasance, or mishandling of assets of the estate?
I don't think I would argue with that. I think that, however, the court, because it ordered, what is brought in this case and what's at issue in this case is the violation of court orders. In effect, the removal of Mr. Posey as the trustee in this case was in effect a sanction for his failure to comply with orders, and that's the way the order now under appeal reads. So if we're talking about relief in that sense, the relief for the violation of the orders was sought from the court that had issued the orders that required him to act.
Did the court sui sponte issue any kind of contempt orders or show cause orders?
Not sua sponte. I'd made a motion for contempt, and the court had a hearing on it and continued it. The record will reflect. And then it was out of that continuance that finally an accounting was filed. Then when the accounting was filed, I filed an objection to the accounting for its insufficiency and raised questions regarding certain other assets that did not seem to be properly accounted for, namely rental income. And that is what yielded the present order that's now before you.
Let me ask you this. The way you characterize the order of dismissal in your answer brief, you make reference to the fact that the court entered an order dismissing the claims, cross-claims, third-party complaints, and other claims, but that the guardian ad litem didn't have any of those kind of claims. Are you making a distinction between dismissing the case as opposed to dismissing the claims and the counterclaims in the case? I mean, was this an order of dismissal that you say was something short of an actual dismissal of the entire case because it was only dismissing the claims and counterclaims?
I would take that position. I don't think the court intended to dismiss any matters relating to the jurisdiction that it exercised. For example, the requirement of the posting of the bond. The record will actually reflect that there was an order on motion for status conference that set it for June the 3rd, 2004, and that order was entered, I believe, on April the 15th, 2004, and sandwiched between the time of that status conference and that order was the dismissal itself. I think the court was treating this as a steady stream. The court dismissed the case at the same time that it had set a status conference with respect to the pending issues relating to the bond and requirements that the court orders be fulfilled. So I see this as a continual stream of the court exercising.
So the court was dismissing the ongoing claims but keeping the case open for whatever other purposes were necessary?
Yes, and I believe that the order entered in July and August had language in it that said it reserved jurisdiction to enforce the terms of the order. And that was never relinquished or set aside. And there were express provisions that the court was retaining jurisdiction to enforce those terms, which it did. It sought to do that. It sought to vindicate its attempt to reach out to the wards to protect them. Of course, it's our argument that the court has inherent jurisdiction in that regard, that jurisdiction cannot be divested through technicality, through the filing of a dismissal. That once the court has reached out to protect a minor, it continues to have the authority to protect the minor, particularly as in a case like this where the court required certain actions to be taken and then the actions were not taken. I don't think that there's a divestment of jurisdiction of the court's inherent authority. That's the meaning of inherent authority, is that it really can't be divested.
You would agree that if the child turned 18, the court would have no more authority over that child, correct?
Yes, I think I would
And
take
if
that
the
position.
child filed a petition of non-age or became married or joined the military, the court would have no jurisdiction.
Was otherwise not under the
So
disability anymore.
there is no ad infinitum jurisdiction that the court has.
And I think that's very reasonable, because the idea of inherent jurisdiction, as it relates, there's many different types of inherent jurisdiction, but this inherent jurisdiction relates to the protection of a minor. If someone is no longer a minor, then there's really no logic to the idea of the court reaching out to
But the
protect.
point is, at some point, the court jurisdiction ends either by the court saying the court has no longer any interest in this case, or the child reaching 18 or becoming married, or some other trigger less than 18 that stops the court from having jurisdiction, correct?
I believe that's correct. I believe that when a person is not a minor anymore, there's no inherent
But a person
jurisdiction.
less
to
than
proceed to a
18
minor
is
over them.
still not subject to the court jurisdiction because the child is now married or in the military, correct?
Not to its inherent jurisdiction. It would have to be invoked through some other method if the court were going to exercise jurisdiction with respect to that person. That would be my position. His arguments in his brief ranged from the guardian ad litem being appointed was limited in scope, but I think the court's discretion in that regard was broad, and the way it was exercised in this case showed that the court had a continued interest in protecting the minors in this case and had interpreted the scope of the authority of the guardian ad litem very broadly. The James v. James case itself points out that the duty of the guardian ad litem is, in fact, the duty of the court itself, that the guardian ad litem is acting, in effect, as an arm of the court with respect to the protection of the minor. He also makes arguments about beyond the framing of the pleadings, citing to a number of cases that state that the court loses inherent jurisdiction of any matter that is not within the framing of the pleadings, but it's our position that all that line of authority is distinguishable with respect to inherent jurisdiction, because the court doesn't lose inherent jurisdiction even over items that were not specifically framed by the pleadings. For example, in this case, the court, in a sense, was in a balancing act in this case, because the trust at issue, the trust under which the minors would become beneficiaries, was under challenge. And the nature of the challenge was that Mr. POSEY had obtained that trust by undue influence or some other nefarious means. And so the court found, even in the order approving the settlement, that there was not any other way to adequately protect the interests of the minors. And that's why the bond was required, because the court obviously had concerns about the circumstances of the trust. There was never an adjudication of the trust, or how it was obtained, or whether it had been obtained by nefarious means or not by Mr. POSEY. It was simply settled. The case was settled without adjudication. And therefore, that's why the court required the bond in this case. The court was always exercising that jurisdiction. The last argument in his brief relates to jurisdiction being lost based on the idea of dismissal itself. And I don't believe it can be. Not the inherent jurisdiction cannot be lost under any circumstances. He's also complained, I think, in his argument just before you now, and he raises it in his brief as well, that there was no opportunity for Mr. POSEY to be served by separate action, to receive separate process, and so forth. I don't think those arguments really have any merit, because all of this was done with process and with involvement and after notice in a hearing. It wasn't as though Mr. POSEY had been deprived of the opportunity to be heard with respect to the claims that were brought against him. There was a hearing. There was a petition with respect to the order at issue. So there was really no deprivation in the sense of due process.
What do you say is the scope of the inherent jurisdiction? There were all these claims and counterclaims and third-party complaints that were dismissed. Would the court have inherent jurisdiction to hear those if the parties got in a feud again over those same issues? Is that part of the inherent jurisdiction?
It's an interesting question, Your Honor. I don't think so. I think that those claims are in fact dismissed and were approved by the order.
So what are the bounds of the inherent jurisdiction?
That's a good question. I think the bounds of the inherent jurisdiction relate to the protection of the minors, which is the reason for its invocation in the first place. So I think the bounds relate to the protection.
So if there were no minors involved in this case, there would be no inherent jurisdiction left with the court.
Yeah, I would agree with that. Unless there were some other basis for, for example, there's inherent jurisdiction to determine jurisdiction, things like that. But inherent jurisdiction has many limitations within our law. It's not, it is not broad and great, but I think it's been invoked in this case with respect to the minors. And that concludes my portion of the argument, unless the board has other questions.
Thank you.
Thank you, Your Honor.
Thank you.
Do you want to address real quickly the argument that the May 04 order dismissed the claims and cross-claims, but not the case itself?
Well, I'm just going to address that. I believe it did. I believe that in reality, that's as verbiage, but that would dismiss the case, because I don't think a court can retain jurisdiction in a vacuum. It has to have some kind of a claim. In fact, that's why I believe that you have process summonses and so forth to frame the jurisdiction. And once the order said all claims, there's nothing left for the court to have jurisdiction over. And you can't have just jurisdiction in a vacuum. So I would disagree respectfully that by saying in any other claim, I think the intent and the only...
Well, there are ancillary matters potentially in litigation that aren't a claim or cross-claim, correct?
Correct.
And there's case law saying that a judge can retain jurisdiction over ancillary matters, correct?
Yeah, that's correct. But generally speaking, that if they do that, that they retain that by the order they retain the jurisdiction. And certainly the court could have said, I retain jurisdiction like it did before. And the 2003 order talking about the bonds, the court was retaining jurisdiction to enforce the mediation agreement and other orders. And that, in a sense, we would say would come under the all-inclusive claim portion of it. But once the court entered the order, I don't know how much more she could have said other than saying, you dismiss the claims and I dismiss the case, because I think the claims...
So the bond requirement that the judge imposed wasn't pursuant to anybody's claim, correct?
No, that was not.
I
wouldn't, I'm sorry, I didn't mean to cut you off there. I wouldn't disagree with the idea that the court had inherent jurisdiction in that instance to condition that on ordering the bond. It's not an issue here, but we take position.
It's not a very strong, very difficult leap to once you say or admit that the court had inherent jurisdiction to require a bond, which wasn't part of anybody's claim in order to protect the children, to say then that the court had continuing jurisdiction to make sure that the provisions of that order were carried out, and they never were. The bond was never posted, and so other steps were taken to ensure the protection of the children, correct?
Well, I wouldn't agree with that, Judge, because the fact that the court had the jurisdiction, inherent jurisdiction to enter that particular order, I think if they wanted to continue the jurisdiction to enforce that or to, for example, modify it, I don't think the court necessarily, if they wanted to come in and modify that, you could just come in with a motion. I don't think that's the type of thing you could do with a motion once the case was over. And the court had the opportunity when it entered.
So is it your position that the court could have entered an order that dismissed claims, cross-claims, and retained jurisdiction to make sure that the previous orders were, but didn't do it? So really we're talking about an interpretation of that order.
I absolutely agree with that. I think that the court could have done it. They didn't do it. Our problem, the way we view it, is that inherent jurisdiction doesn't give the court the opportunity to, in effect, do anything it wants to, irrespective of the rights of the other parties to the litigation. If it only involves the children, obviously the inherent jurisdiction, they've got the power to do that, but just to invoke inherent jurisdiction, and by doing that, entering an order compelling some third party who's never been properly served or never had jurisdiction invoked over that person to come in and answer and defend, we don't believe the court has the power to do that.
Now you're backtracking on your early, because what I hear you saying is that the court didn't have authority to require your client to post a bond without service of process and a pleading that required that. I mean, Mr. Posey was in the litigation. The court exercised its inherent authority, which you said it had a right to do, and and required certain actions of Mr. Posey without any kind of summons or pleading or service. And you're agreeing that that was proper, so
Because I think that was part of that case, Judge. I think that part of a guardian ad litem's position, I would view this much like a personal injury case, where if the guardian ad litem comes in and represents that child, and the court enters an order to protect the child with regard to the settlement or whatever, I think that's part of the case. Maybe not been part of the actual, was there negligence or not negligence. But I think once the judge dismissed this case and specifically said, and all claims, I believe that concluded the case. And if they wanted to resurrect it, I don't think through just an argument of inherent jurisdiction, which basically, if you read his brief, means they can do anything they want to do, they would have had to initiate some additional action and bring an action. And one other point I think that was raised, I do think they're not out of court if the court agrees with the appellants in this case. I mean, they're not out of remedies, they're not damaged. All they have to do is come back in, they have the power to come in, file appropriate relief. And so it's not like if they're not protected now that protection is gone. So we believe that the court did not have jurisdiction and acted improperly, and that that action should be set aside. We would so request.
how could the guardian come into it? I mean, it appears that the appointment, at least of the guardian, ends whenever the case is finally over.
Right.
It was for the case. So you would agree, I guess, that the guardian couldn't go and initiate an independent action.
I would agree with that. I agree with that. I think that
Children unrepresented would be on their own to try to.
And I
they
think
needed protection, and
I think that I believe that they would have to seek some method of accomplishing it by getting independent, which in effect we've argued, and as we view it, the guardian is in a sense morphed into that type of thing anyway. He's been acting more as their personal representative. He's filed petitions to approve cars, petitions to approve distributions. These aren't really the acts of a guardian. Technically, they're just protecting their interest from, absconding monies or that type of thing. So they certainly have their recourse. Thank you.
Thank you, Counsel.